law is my neighbor? The answer seems to be the person who are so closely and directly affected by my act that I ought reasonably to have them in contemplation. As being so affected when I am directing my mind to the acts or omissions called into questions. You must take reasonable care to avoid acts or omissions which you can reasonably foresee will be likely to injure your neighbor.
The concept of duty of care negligence is derived from Lord Atkin's famous neighbourhood principle, which was established in the case of Donoghue and Stevenson. Lord Atkin is a distinguished judge who is also credited as a principal architect of modern tort law. In the case of Donoghue and Stevenson, Mrs. Donoghue fell sick after drinking ginger beer from an opaque bottle which contained a decomposed snail in it. As she had no contract with the manufacturer, the key question arose: did the manufacturer owe her a duty of care? The House of Lords ruled in her favour, affirming that the manufacturer owes a duty of care to the consumer even without a direct contract if harm is foreseeable. Lord Atkin stated in the neighbourhood principle that you must take reasonable care to avoid acts of omission which you can reasonably foresee would likely injure your neighbour. He described the neighbour as people so closely and directly affected by your act that you ought to have them in contemplation. This principle introduced a general test of duty of care based on foreseeability, proximity, ultimately shifting from case-by-case rules to a broader duty concept. This principle has profoundly influenced English tort law and extends to Malaysia, which adopts the same common law foundations. Malaysian courts apply the neighbourhood test when determining duty of care. Thus, the case of Donoghue and Stevenson laid the groundwork for modern law negligence in both countries. Now, we're going to be getting inputs from Professor Danielle on the relevance of the neighbour principle.
Today, I'm going to talk about the neighbour principle. Honey van Rijswijk stated that the case of Donoghue v. Stevenson was decided on moral value, and that moral value continues to be of importance to tort law. The decision in this case has laid the foundation for the development of duty of care in modern negligence. The biblical notion of not hurting your neighbour associates morality to an individual legal duty to the public. From food contamination to shareholders' loss, the neighbour principle is interwoven into the fibers of the legal system. The conspicuous advantage to the neighbour principle is the expansion of negligence, which simultaneously contributes to the protection of civil rights. Duty of care now extends beyond contractual relationships. The element of proximity also helps to accentuate the responsibility of road users to others, or the duty of a doctor to provide proper treatment to their patients. The case of Bolam and Friern Hospital Management Committee illustrates how doctors are required to perform their duty in accordance to how accepted standardized procedures are. In this case, the court ruled that the doctor did not breach his duty. Apart from that, the neighbour principle has led to the Caparo test, which in return has established reasonable foreseeability. This element is crucial in allowing judges more discretion in complex cases. Although this is an objective test, it enables parties to be judged based on whether their actions were reasonable. Referring to the Malaysian case of Lunos and Renberhan, so UC Talk, the court held that there must be a relation between damage and wrongdoing. In this case, it was not reasonably foreseeable for the appellant to be responsible for the plaintiff's compromised data. However, prior to this decision, the Session Court held the appellant accountable merely for the fact that they were registered by the Malaysian Security Commission cryptocurrency platform. By using the objective test of reasonable foreseeability, the judges did not impose an unfair liability to the appellant. Its relevance, however, may be argued due to the limitation faced in applying the principle. In the case of Al Coxon, Chief Constable of South Yorkshire Police, the court was reluctant to include secondary victims under the doctrine of duty of care. The case concerns the negligence by the people which led to a stampede and the death of 95 people in the Hillsborough football stadium. The relatives brought a claim of psychological trauma due to the live broadcast of the crush. The House of Lords decided against the claimants. This ruling contradicted the very element of reasonable foreseeability. Joseph Smith criticized the principle, connoting that the lack of distinction between injuring your neighbour and performing a positive act to prevent harm has blurred the line between law and morality. Furthermore, the neighbour principle has been refined and is not a test that can be used on its own. The sole reliance on proximity and foreseeability were considered as superfluous and would only weaken the principle's certainty. Thank you.
We're going to get input from lawyers on the development of English law and its refinements.
As it was briefly mentioned, the neighbor principle was first introduced in the case of Donahue v. Stevenson. It established that a duty of care can be imposed on individuals who are not in a contract. In the words of Lord Atkins, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. With this, it helped establish the foundation of negligence within the law of tort. A case that highlights the use of the neighborhood principle is the case of Home Office against Dorset Yacht Co. Limited. This case uses the neighbor principle to impose a duty of care on the officers who are affiliated with the Home Office. While the officers were not explicitly at fault for committing the crime, the Borstal trainees who did commit the crime were under their supervision, and therefore they owed a duty of care towards the boy and a responsibility for their actions. This helped increase the neighbor principle to include liability for the acts of third parties. Moving on to the duty of care tests, there are four: the reasonable man test, the two-stage test, the Caparo test, and the Bolam test. These are tests that were introduced as a result of the neighbor principle and the expansion of the law of negligence under tort law. First of all, the reasonable man test was introduced to determine whether an individual breached their duty of care. This was done by comparing the tortfeasor to a hypothetical man and asking if any reasonable man would have acted the same in those circumstances. If their actions did not coincide with what a reasonable man would do, then the tortfeasor would be liable for a breach of duty of care. A case that can be applied to this would be the case of Nettleship against Weston, where a learner driver was held to the standards of any other driver when they had caused a road accident that inflicted injury on their passenger. By this standard, the learner driver was partially liable and therefore owned a duty of care to the passenger. Moving on to the two-stage test, this test focuses on two steps. First of all, is there sufficient proximity or relations between the tortfeasor and the plaintiff? If yes, we then move on to the second step, which is, was there sufficient consideration? This test was established in the case of Ands against Merton London Borough Council, which looked at whether the council was liable for the faults concerning their building's foundation, which was laid out by a third party. It was held by the court that Merton London Borough Council was at fault for not checking. Therefore, they failed to fulfill their duty of care towards the tenants. Moving on, the Caparo test was established after the two-step test, as it would later replace it due to the two-step test being too broad. So instead of two steps, the Caparo test focuses on three different steps, which consist of: the first one, was the damage due to foreseeable causes? The second one, was there sufficient proximity? And finally, is it fair and just to apply the duty of care? Now moving on to the final test, the Bolam test focuses on the duty of care in the medical field. It assesses whether a member of the medical field is at fault for a duty of care breach by assessing them against other medical professionals and standard procedures. This test was first established in the case of Bolam against Friar Hospital Management Committee, in which the patient received injuries as a result of the treatment. This case was therefore used to assess if the treatment would have been conducted by any other medical professional, and consequently, it highlighted the standard of reasonable care held by medical personnel.
Now we're going to be looking into the refinement of neighbor principle. Lord Atkins' neighbor principle needed to be refined because its initial articulation in Donahue v. Stevenson was thought to be too expensive. Courts eventually realized that applying it indiscriminately could lead to indeterminate liability, particularly in situations like negligent misstatements. Lord Atkins' neighbor principle was expanded to cover economic harm in addition to physical harm, specifically in Hadley, Byrne and Co. versus Heller and Partners. In Home Office versus Dorset Yard, the court held the Home Office liable for foreseeable harm caused by escaped trainees, but Lord Wright emphasized the need for policy consideration to limit such liability. This led to the development of more structured tests for determining duty of care, moving away from Lord Atkins' broad principle. The two-stage test from Ands versus Merton London Borough Council sought clarity but was criticized for being too broad. This was replaced by the Caparo test, which introduced a three-stage approach, balancing foreseeability with policy concerns and offering judges more control in deciding when to impose a duty. In Hill versus Chief Constable of West Yorkshire, the court refused to impose a duty on the police, citing potential excessive burdens and lack of direct harm. However, challenges remain. The principle struggles with modern harms, particularly psychiatric injuries, and courts limit claims to avoid an overload of lawsuits. Cases like Alcock versus Chief Constable of South Yorkshire, police show reluctance to extend the duty of care to secondary victims. Digital harm, which complicates the concept of proximity, and ongoing policy concerns, such as balancing societal costs with individual justice, further complicate the application of neighbor principle.
Now we're going to be getting input from lawyers on the development of Malaysian law and its refinements.
I'll be talking about the adoption of Malaysian law of neighbourhood principle in the Malaysian legal system. So how is it adopted? Firstly, we know that it's adopted through Section 3, Clause 1 of the Civil Law Act, which allows the application of English law where there are gaps in the Malaysian legal system known as the lacuna. This allows the adoption of the neighbourhood principle that was established in the case of Donahue against Stevenson to be applied in Malaysian law by Lord Atkin. Malaysian courts implemented the principles of you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. This has helped develop Malaysian courts in making decisions in cases regarding tort cases and how it has been applied and expanded in Malaysia. There are two cases which I'll be talking about, which is firstly Abdul Malik bin Idrus and others against Tan Ji Han. This case was about a police car chase between three people. Firstly, the police, which is the appellant. Second, a Proton Wajah driver. And thirdly, the defendant, which is the third party that was injured because of this police chase. The Wajah was driving against traffic in an attempt to escape the police. The Wajah finally collided with the defendant, and the defendant was seriously injured, and instead of suing the Wajah driver, he sued the police. What did the court held? The court held that the foreseeability was there, but court said it was insufficient, therefore they applied the neighbour principle. The neighbour principle was used in this case to show that the appellant did not fall under the category of persons who are closely directly affected in contribution to the accident. It was held that it was purely the fault of the Wajah driver and the defendant should have sued him instead. Therefore, the police was not charged with anything. Secondly is Kerajaan Malaysia against Jumat bin Mahmud. What happened here? A pupil in school pricked a student's thigh, which resulted in a shock and the end of a pencil hitting the eye of the respondent, causing the respondent to having to remove the eye. The respondent's father sued the school, claiming there was insufficient supervision by the form mistress. What was the judgment? The judgment was based on reasonable foreseeability and the neighbour principle. In this case, the judge held that even if the injury was not foreseeable, as even the constant vigilance in the classroom would not cause harm. Therefore, the neighbourhood principle was applied and the school was not charged with anything.
So the refinement was necessary in Malaysian courts because the original principle derived from Donahue and Stevenson in 1932 was too broad and simplistic, and for more complex cases in the Malaysian courts. So the principle's reliance on only foreseeability was insufficient to define the scope of duty of care in many situations, which led to uncertainty and inconsistent applications. There was a need to incorporate additional factors like proximity and normative considerations of fairness, justice, and reasonableness to ensure that the duty of care is imposed appropriately. Malaysian courts have faced challenges in balancing individual rights with public interest, especially regarding discretionary powers of public authorities, requiring procedural safeguards and reasonableness tests beyond mere foreseeability. Refinement allowed courts to better tailor negligence law to Malaysia's legal and social context, ensuring that duty of care owed is both legally sound and practically fair. These reasons led Malaysian courts to adopt the Caparo test, which is far more structured, centering around foreseeability, proximity, and fairness, and as they should be considered together before imposing a duty of care. Malaysia refined the neighbour principle because relying solely on foreseeability didn't work. Cases were becoming more complex. Public authorities, contractors, consultants, large-scale developments, courts needed fairness, proximity, and policy considerations. In the case of Batu Kemas, multiple parties were involved. The government, Tenaga Nasional, and contractors. Only Caparo's structured approach could clarify liability. In Dr. Abdul Hamid, the Malaysian Court of Appeal openly acknowledged that foreseeability alone was insufficient. Proximity and fairness became equally essential. Malaysian courts refined not
rejected the neighbor principle to fit better within Malaysia's social and legal context.
Now we're going to be getting inputs from PhD students on the evolution of duty of care and its modern approaches, as well as the comparison of old and new approaches.
The modern approach to determining a duty of care has evolved through three major cases: Donahue and Stevenson, Ans and Merton, and Caparo and Dickman. Each represent a shift in how courts balance foreseeability, proximity, and policy. Donahue and Stevenson introduced the neighbor principle, establishing that a defendant owes a duty to person closely and directly affected by their actions. However, as negligence cases expanded, the courts needed a more structured framework. This led to Ans and Merton, which created the two-stage test, foreseeability and proximity, followed by a consideration of policy factors. Critics argued that Ans allowed liability to expand policy concerns too late in the analysis. To correct this, the House of Lords in Caparo and Dickman introduced the current three-stage test, which is now central to the modern approach. The task asked: first, was the harm reasonably foreseeable? Second, was there sufficient proximity? 3, is it fair, just, and reasonable to impose the duty? This final stage introduces flexibility but also judicial discretion, which can make outcomes less predictable. Malaysia has largely adopted the Caparo approach. A key example is the Uniphone Sidran Berhad and Chin Boon Lit case. In this case, a newspaper published information about how expired phone cards could be misused. Uniphone sued, claiming economic loss. They applied Caparo. The misuse was already widely known, so the loss was not reasonably foreseeable. There was no proximity between the newspaper and Uniphone. Imposing liability would restrict public interest reporting, so it was not fair, just, and reasonable. Thus, no duty was found. This case shows Malaysia's consistent use of Caparo, especially in pure economic loss situation. In Malaysian exception, however, Malaysia does not apply Caparo rigidly. In Arab Malaysian Finance and Stephen Foa case, arising from the Highland Tower collapse, the court focused primarily on foreseeability. Given the obvious risk to public safety, the court relaxed the strict Caparo sequence and allowed recovery, even for pure economic loss. This illustrates that while Caparo is the dominant framework, Malaysian courts retain flexibility, especially in cases involving large-scale harm or public safety concerns. That's all.
I will be assessing the evolution of duty of care tests and will be highlighting the strengths and weaknesses of each approach. Firstly, I'll begin with the neighbor principle in Donahue-Stevenson and its strengths. It allowed a duty of care to exist even without a contractual relationship. It was recognized in this case that manufacturers owe responsibility directly to their consumer. It also introduced a moral dimension into negligence law, where Lord Atkins said you must take reasonable care to avoid omission that will likely injure your neighbor. Means that if you can foresee harm towards someone, then you should take reasonable precaution to prevent that. And this made the law feel more human and fair. And its weaknesses: the test was too broad because the term neighbor was defined as so vague it says anyone closely or directly affected, and this ambiguity will lead to floodgates of potential claims. And also it expanded judicial creation where judges have more room to interpret what neighbor means, and this can lead to inconsistency in the law. And next is the two-part test in Ans v. Merton, and its strength: it increases access to remedies where plaintiff automatically started with a prima facie duty of care, which placed them in a favorable position. This provides a clearer structure than the neighbor test. Its weaknesses: again, it is too broad in its application and may make it too easy to find a duty and also lead to floodgates of potential claims. The Caparo test, the strengths: it provides structure and control by restricting its application, and this is done by introducing the third element, that is fair, just, but reasonable to impose duty, and this prevents unlimited liability. And its weaknesses: it opens to a high degree of judicial discretion in the third element, and this is subjective because what may be fair to one judge, it may not
not be fed to the rest, and this also creates uncertainty and makes the law less predictable due to its varying outcome across cases. And it also places a heavier burden on the plaintiff, who must satisfy all these three requirements in order to prove a duty of care to exist. So, to conclude, the development of duty of care tests demonstrate the law's attempt to evolve from generosity to precision. Each test tightens the scope of liability, aiming to deliver fairness without overwhelming the legal system.
In conclusion, Lord Atkin's neighborhood principle in the case of Donoghue and Stevenson established the foundation for modern negligence, linking moral responsibility with legal duty. In English law, it evolved through the case of Andrew Merton and Caparo v. Digman, refining the duty of care into structured tests according to foreseeability, proximity, and fairness. Malaysia adopted and adapted this principle under Section 3 Sub 1 of the Civil Law Act, applying it to cases such as Tenaga Nasional Berhad v. Batu Kemas and Kerajaan Malaysia v. Jumat. Despite its limitations, the neighbour principle remains central to negligence law, shaping how both Malaysia and the UK jurisdictions balance fairness, justice, and accountability in defining duty of care. Thank you.